This is Michael Popok, Legal AF. Let's get to the bottom right now of a rumor and a lie that is being circulated by Donald Trump, both in advance of his indictment and in the indictments unsealing today, 38 counts across 8 different federal statutes, that something was untoward or underhanded or unprofessional or the result of misconduct between the Department of Justice and certain key witnesses, now indicted co-conspirators like Walt Nauta, Donald Trump's body man, valet, steward, whatever you want to call it, who was instrumental in moving all of the boxes around in a giant shell game of Donald Trump's creation between Mar-a-Lago, the White House, Bedminster golf course up in New Jersey, SUVs, using maintenance workers to help him do it. That Walt Nauta, now co-defendant Walt Nauta. There's a charge out there being made by Walt Nauta's attorney, Stan Woodward. Let's put him up on the screen. Stan Woodward, a lawyer in Washington, D.C., who, let's be frank, is being paid by the Save America PAC by Donald Trump. Stop right there. That's something else the Department of Justice is looking into. Influence peddling and witness tampering by Donald Trump by having his lawyers, the lawyers for these witnesses, and now co-defendants being paid by the same Save America PAC. Where is the allegiance of the lawyer? Is it to the Save America PAC and Donald Trump, or to his own client now? Something I assume the Department of Justice is going to bring up in the future. How can this PAC pay for both Donald Trump's lawyers and Walt Nauta's lawyers when their interests are not aligned? We'll put that for another day, but the attack on the professionalism of the Department of Justice, which knows no boundaries with Donald Trump, has now taken the form of accusing Bratt, one of the leading members of the Department of Justice, who's the chief of the Counterintelligence and Export Control Section of the National Security Division of the Department of Justice, and was the leading member of the Department of Justice for all things Mar-a-Lago, who met with Walt Nauta and his lawyer, Stan Woodward, in November of 2022 in a meeting called by the Department of Justice. Now there's a claim and a letter that's been filed under seal, so we don't know exactly its content, now, many months later, by Walt Nauta's attorney that says he was manhandled inappropriately during the meeting with Bratt, because I guess he wasn't wearing his big boy pants that day in the meeting. And in the meeting, he said that a number of things that are completely not objectionable and would be professional malpractice if the Department of Justice didn't do it. He said that the Bratt came into the meeting trying to force his client to flip on Donald Trump, or they would indict him for Walt Nauta's own false statements to the Department of Justice in their prior meetings with the Department of Justice and the FBI, which, by the way, turned out to be true. So Bratt was telling the truth. You either play ball, flip on your client, save yourself, man, or you're going to get indicted along with Donald Trump. So he told him that. He said it's in your client's best interest to avoid being indicted and to cooperate. So far, no prosecutorial misconduct. And then he had with him a folder, apparently, of background information of the lawyer he was about to meet with. Completely appropriate. I do it all the time in my civil practice. I don't conduct a meeting until I go on LinkedIn, bios, pull up articles, read about their media and publicity of the lawyer that I'm dealing with. And I have my staff put together a dossier or white paper, and I do that here in my own practice. So of course the Department of Justice does that. They walk in with a folder, and they knew everything they needed to know about one Stan Woodward, including that he was applying at that very same time that he was taking money from the Save America PAC to represent this client for Donald Trump, Walt Nauta. He was applying for a D.C. municipal judgeship at the same time. I guess his law practice is not going that great. He wants to become a judge. And they mentioned it. And they mentioned it in the context of trying to soften him up to do the right thing, to have his client come in from the cold and avoid being indicted. Note to Stan Woodward, your client got indicted. You should have taken the deal when it was offered. Now it's not going to be offered, or it's going to be much less, because you get, when you're the first in, like Walt Nauta, and you help the Department of Justice, you might get full immunity. But when you're not, and you're being uncooperative, and the other side believes that you as the lawyer is being also uncooperative, then you're going to have a meeting like the one that you think was totally inappropriate when it wasn't. And so the Jay Bratt apparently said to him, at least that's according to reporting, in the meeting, said to the lawyer for Walt Nauta, I didn't think you were a Trump guy. You know, I know you're going for that judgeship, but, you know, I'm surprised you're taking such a hard tack with us on this. The fact that it's publicly reported that the Save America PAC is paying Stan Woodward, which it is, and that may or may not have got mentioned in the room, and the fact that he's publicly applying for a job in the DC, for the DC Municipal Court bench, also publicly available, and that got mentioned in the room. I don't see the quid pro quo, but in Donald Trump's list of grievances that he uses to collect money from unsuspecting donors, he said, oh, is a quid pro quo, a bribe. A bribe was offered. Flip on Trump, and you'll get that municipal judgeship. That's not what Jay Bratt said. That's disparate data points that are being tied together in a way that don't connect. I can say to you in a meeting, nice to meet you, Stan. Have a seat. Let's just play this out. So, first of all, we know a few things. We know you're being paid by the Save America PAC, totally appropriate to raise in the meeting the funding for the client, because there may be an issue down the road of a conflict of interest and he wants to get that on the table now. So check, totally appropriate conversation. I looked up your background. I see where you worked. You worked at this law firm, Aiken Gump. We know your partner, who used to be the general counsel for Tip O'Neill in the House of Representatives. You know, you have a good firm, good reputation. Why are you doing this? We didn't take you as a Trumper. That's okay to say. What's wrong with that? Check, that's fine. And then ending it with, I also see you're going for a municipal job. You know, I think you'd want to do the right thing. He didn't say, hey, do it. Hey, do it, dummy. And I'll put in a good word for you with Joe Biden, and you'll get that judgeship because it all comes out of the White House. First of all, wake up, Mr. Woodward. Prosecutors, even at the highest level of prosecutors, even Merrick Garland himself, can't pick up the phone, don't pick up the phone, call up Joe Biden and tell the White House counsel about who to pick for municipal judgeships. Not happening. Makes for great theater, makes for great, performative BS that you can use to separate your donors and cult followers from their money, but has no role at all. And you should be embarrassed that you filed a letter now, apparently, Mr. Woodward, talking to you, with Jeb Boasberg, the chief judge for all things grand jury in the District of Columbia, claiming some sort of prosecutorial misconduct that happened in November, but you're just getting around to complaining about it now. The staleness of time, the passage of time, the snailness of the event suggests to me that you're being put up to it by the Save America PAC and Donald Trump in order to give Donald Trump a talking point. Or ultimately, the new lawyer for Donald Trump, as of this afternoon anyway, on indictment day, Todd Blanche, to give him a talking point. But it's not prosecutorial misconduct to know who your opponent is in a negotiated process. Now, apparently Stan Woodward was so upset because he wasn't wearing his big boy pants that day and what transpired in the room with the Department of Justice leaning on him to lean on his client to do the right thing and testify against Donald Trump and avoid indictment, that he told people, he told the Department of Justice, I'm never going to meet with you again unless you give my client full immunity. Well, they weren't there for full immunity. They weren't there unless there was a proffer being properly provided by his client, where he came in, given a sworn statement under an intense grilling and Q&A to develop his testimony under oath. Only then could they evaluate an immunity deal. No prosecutor can just give immunity. They have to evaluate the facts that can be provided by that particular witness and where it fits into the case. And if it's of value to the case, before he gives somebody a free pass. That's why one of the decisions that prosecutors have to make in exercising their discretion is whether to and who to give any level of immunity to. Limited immunity, transactional immunity, full immunity, what we call queen for a day type immunity, which is the transactional immunity. It depends on the quality and quantity of information and the value of that information and whether it can be trusted by the prosecutor and will help him or her make the decision to indict and or to prove the case at trial beyond a reasonable doubt. You might have something to say, but if 4 other people better connected than you, better connected to the matter than you, factually, are already cooperating with the government, you're out of luck. Government doesn't need you. But if you're first in and you're the guy who touched the boxes under the videotape at Mar-a-Lago, and you moved to the Bedminster, and you put him in the car, in the SUV, and you enlisted the maintenance worker to help you move the boxes, and you got rid of the videotape, and maybe you flooded the server room with the pool being emptied at Mar-a-Lago. I'm talking to you, Walt Nauta. If you did all those things, and you try to interfere with Evan Corcoran's job of delivering all of the records back to the government in response to the subpoena, and you interfered with that, then you're first in. You'll get full immunity. That's what the government was telling your lawyer in November. I don't know what was reported to you, but that's the deal that was on the table. If you came in, gave a full proffer, full cooperation, and answered all the questions. Because at that moment in time, that snapshot in time, in November, you were not seen as reliable, trustworthy, or telling the truth. You were spoon-feeding the government, and many of the things that you spoon-fed the government turned out to be inconsistent with other evidence developed from other witnesses and videotape and tangible evidence that was out there. So you had one last chance, and that's what Jay Bratt was telling Stan Woodward, and that should have been the takeaway from the meeting. Come in from the cold, cooperate completely, sit in a room for several days, develop a coherent, truthful, authentic testimony against Donald Trump, and we'll give you full immunity. Not Stan Woodward, oh, I'm annoyed that you mentioned something on my LinkedIn or some public filing of me running for office or trying to get a judgeship. And now Trump, because he reported it back to Save America PAC, back to Trump, is trying to use it for his benefit. I got news for Donald Trump and for Stan Woodward. You know who's going to use that meeting now to your disadvantage? The Department of Justice, because they'll probably move to disqualify Stan Woodward representing or being paid to represent Walt Nauta through the Save America PAC, because the interests of Donald Trump and Walt Nauta as co-conspirators are not aligned. And if they're not aligned, then ethically, I'm not sure, under the appearance of impropriety, that lawyer can take funds ultimately that's coming from Donald Trump's fundraising and grift to represent a client whose interests are antagonistic. And that's something that's going to have to be sorted out in motion practice in front of the eventual federal judge in Florida. I'm going to cover it, all the development, just like we did leading up for the last 2 years to the indictments in New York 2 months ago, here in Miami, Southern District today, this week. Twice indicted Donald Trump, but we're not done. We've got arraignments. We've got motion practice, motions to dismiss. We've got bond hearings and bail hearings. We've got continued cooperation or lack of cooperation and the addition through superseding indictments, new amended indictments of new counts and new people. And we'll unpack it all here on Hot Takes, just like this one you can only get on the MeidasTouch network. And when I'm not doing this and practicing law, I co-founded and co-anchor the leading podcast at the intersection of law and politics on the MeidasTouch network or anywhere else, called Legal AF. You can get it on YouTube and subscribe to the MeidasTouch network. You can get it on podcast platforms, all of them. And if you like this particular hot take that I'm doing, like I do every day, give me a thumbs up. It keeps the quantity and quality coming to you. And you can follow me, Michael Popok, on all things social media at MS Popok. This is Michael Popok, Legal AF reporting.
Lock him up. Indictment season is upon us. Celebrate with the new Indictment Season t-shirt and v-neck exclusively at store.meidastouch.com.